go?
Yes.
Okay, I'll start admitting people into the room.
Good afternoon, everybody.
Good afternoon.
Hold on, I think I have my volume off. Yep.
Give me just one moment. I'm waiting for everyone's audio to connect.
Sorry. Hello. Good morning. Good afternoon.
Good afternoon, everyone. I'm Judge Blake Adams. We're here for civil motion hearing dockets this afternoon. We have 4 cases on the docket. Let me go to the first case I'm going to call is Summit Wood Works LLC v. Monette Gustave, case number 19CC412.
Yes, Your Honor. Jose Aguirre on behalf of the plaintiffs.
Good afternoon.
Good afternoon, Your Honor. Giovanni Diaz on behalf of the defendant.
Good afternoon, Mr. Diaz. All right, I believe we're here on the plaintiff's counsel's motion to withdraw as counsel of record. Is that correct?
That's correct, Your Honor.
Okay.
This is a case where, unfortunately, I was not able to get client consent to withdraw because I've lost all communication with my client. I tried to send them notice of this hearing via every available means that I had, including every single address on Sunbiz, and all those were returned to me. So return to sender. So I don't know if they have notice. I've gone through every step I possibly could to notice them, but that's the reason why I filed my motion to withdraw.
Okay. All right. Anything from you, Mr. Diaz?
Not really, Your Honor.
Okay. All right. Well, I have reviewed the motion, and based on the information provided here today, I'm going to grant the motion to withdraw.
Your Honor, do you want to set and again, I don't know if I can actually get this information to them, but if you want to set maybe a status date for a month or two, so that I can try to get them an opportunity to show up with new counsel, or I'm not sure how Your Honor usually handles motions to withdraw.
Mr. Diaz, what are your thoughts?
You know, I thought the same thing, some sort of measure to maybe require the plaintiff to appear as counsel or decide to declare as pro se. It's really a situation that's both out of our hands.
Sure. Okay. Let me look at my calendar.
And what I can do in the proposed order, I can say that they have to enter an appearance or appear on this date for the status conference.
Okay, I think that would be good. Mr. Diaz, how does your, I've got March 4th at 1:30. Or I have,
Sorry, break.
I'm sorry? That would be great. Are you still there?
I didn't hear anything you just said.
Okay.
Can you hear me? Hello?
Yes, I think your internet keeps freezing. I've got March 4th at 1:30, or I
Hello?
have, can you hear me, Mr. Diaz? I think you might be having technical.
Yes. 30.
All right, so that date works for you?
March 4th at 1:30. Give me 1 second, please. Yeah, I can do March 4th at 1:30.
Okay, all right. So basically, we'll have the order say that the motion to withdraw is granted. The case shall be set for a hearing for March 4th at 1:30, at which plaintiffs are to appear or have new counsel appear.
Perfect. I will send that proposed order to Mr. Diaz to review, and then we'll submit it to your honor.
All right, very good. All right, thank you both. Have a great afternoon.
Thank you.
All right, the next case I'm going to call is the Kidwell Group LLC, doing business as Air Quality Assessors of Florida, v. Tower Hill Prime Insurance Company, case number 20 SC 2829.
Good afternoon, Your Honor. Law Xavier Simmons on behalf of the plaintiff, the Kidwell Group.
Good afternoon.
Brett Norvig on behalf of Tower Hill.
Good afternoon. Excuse me. Excuse me, just one moment. Okay, sorry about that. Okay, looks like we're here on a pretrial conference. Give me one moment to pull up the case here. All right, I believe the plaintiff filed a notice of setting action for jury trial, which prompted this pretrial conference. Where are the parties at with this case? I'll start with the plaintiff.
Well, Your Honor, I think this case is still in its early stages. I know that a notice of appearance was just filed by opposing counsel back in November, and the answer was just filed back in November as well. I don't think a lot of work has been done on this case. I don't think we've been to mediation yet for this particular case.
Okay. Mr. Norvig?
Yes, Your Honor, that's accurate. Nothing has been done really other than answering the complaint. We are in the process of putting together our motion for summary judgment, and that should be filed within the next day or two. So this is, as plaintiff's counsel stated, this is in the very early stages.
Okay. All right. Well, I guess the notice of setting action for jury trial is what triggered this, the court's decision to set a pretrial conference. So it doesn't sound like we're anywhere near time for setting this case for a jury trial. You both,
Yes, Your Honor.
You would both agree?
I agree, Your Honor.
Okay.
Yes, Your Honor.
All right. In that case, it sounds like we'll just wait to hear from the parties as to whether or not we need to set a hearing, whether it's on a motion for summary judgment or another motion. So we'll just leave this case pending for now then. Now, if we do go to trial, is the plaintiff still requesting a jury trial? Looks like this is a small claims case.
That is correct, Your Honor. We're still requesting a jury trial.
Okay. All right. Well, we'll see where we're at with jury trials for county civil cases when the time comes. Okay. All right. Well, thank you both for being here today, and we'll be in touch.
Thank you, Your Honor.
All right. Thank you.
Bye-bye.
All right. That brings us to Carrie Colvin, doing business as Creative Spectrum v. Scott DeHoogie and BWG Companies, 20 SC 679. We have Ms. Colvin present.
Yes, I'm Carrie Colvin.
All right. Good afternoon, Ms. Colvin.
Hello.
All right. We're here on the affidavit and notice of non-compliance that you filed.
Yes.
I'll note for the record that the defendant is not present. The reason I ordered that this case be set for a hearing, let me pull up, I believe, let me see. My concern, Ms. Colvin, is that I didn't see that you filed an agreement in the court file. Was there a signed agreement between the parties?
I forwarded the information to Mr. DeHoogie and BWG, and they never signed it and forwarded it back to me. I attempted to contact him, his secretary, his bookkeeper. They're unresponsive.
Okay, so it sounds like there was not an agreement then.
There was verbally, but he didn't sign anything following our trial with the pre-trial conference with you.
Okay, so anytime a settlement has to be in writing, signed by both parties. Oh, can you hear me?
I did. I'm just trying to follow. This is all very new to me. I've never done anything I've never had to do anything like this before. So I'm feeling my way through it.
Sure. So because they never signed the agreement, then there is no agreement, even if there may have been indications of it verbally. I do see that Mr. DeHoogie filed something, and it states, neither Scott DeHoogie nor BWG companies admit to any liability to the plaintiff in this matter. In non-binding discussion with the plaintiff prior to trial, Mr. DeHoogie agreed to reach out again to the homeowner where the work occurred to collect on behalf of the plaintiff. To date, no contact with the homeowner has been made. It was represented that it was believed 50% of the invoice work amount due would be acceptable to the homeowner for payment. The amount discussed was $1,992.50. It was further represented that 100% of all amounts collected from the homeowner on behalf of the plaintiff's invoice would be given to the plaintiff. Sounds like we need to set it for trial.
I think so, unfortunately. Now I am a little confused because all the paperwork that I've been filing, I've been instructed to provide him with a copy, and I have. All my exhibits, everything. However, I haven't received any copy of his response. He's been completely unresponsive to me. I have a signed contract with him or his representative.
Yeah.
So how do I go forward?
So right now, I'm going to set it for trial. Okay.
Is this going to be a Zoom trial?
It will be a Zoom trial.
Okay.
Okay. Anything that you've already filed, we can use as exhibits. If you have additional physical evidence that you would like to present at the trial, you'll need to file that with the clerk. You are obliged, or you're required to send copies to the defendant. Obviously, if he has any exhibits that he intends, he's to file those also and provide you with copies. If he doesn't, you can bring that up at the trial.
Okay.
Okay.
Your Honor, I have her exhibits right now.
You have her exhibits.
Yeah.
Have they already been filed?
No.
Can you file them, or do you want to send them to my office? Jane?
I can send them to your office, Your Honor.
Okay, why don't you send them to my office, and then I'll have Julianne keep those in a file until the trial date.
Sure.
Okay. All right, let me look at my calendar here.
May I ask you another question?
Yes.
Okay, so I don't believe I have any more tangible exhibits to
Okay.
file. However, I do have witnesses
Okay.
that heard the instruction I was given, and then I'm wondering, should I subpoena the man that actually gave me verbal and text and email consent to do the work that was employed by BWG? I will add, he no longer works with BWG.
Sure. So if you have witnesses, you'll need to file a witness list and provide that to the defendant. And then you'll need to let your witnesses know when and how to log on to the Zoom for the trial. If you have someone that you wish to call as a witness that you feel like you need to have a subpoena issued for, then you'll have to do that.
So do I understand this correctly, that if someone just agrees to appear on my behalf, I can file that they are a witness with you and then just notify them how to log on?
Correct.
But if I think they might be a little reluctant or not show up on time, then they need to be subpoenaed?
That's correct.
Okay, and what happens if they don't? I don't know. I'm gonna have to do a little bit of homework to figure out how to track down the guy that hired me, and I think he might be just as sneaky as the people he was employed by. So what happens if he doesn't show up?
If a person is under subpoena to be present and they don't show up, you can request a continuance, and that an order to show cause be issued by the court for the witness to appear before the court to determine why they ignored their subpoena.
Okay.
Which could ultimately result in a contempt of court hearing.
Okay, and how do I find all of these forms on the Clerk of Court's website as well?
That I don't know. I know that they have many forms on there.
Yes.
So you'll just have to look to see what forms they have available on there.
Okay.
Okay.
All right. So as long as I have notified the court in some fashion, then whenever a witness logs on willingly, that should be good. And as far as a subpoena, I'm just going to have to figure that out. Is it served by a police officer as well, or do I deliver it?
I don't know the answer to that.
Okay. All right.
Okay.
Obviously, I'm swimming in water I've never been in before.
You can see our customer service. They could probably tell you.
Okay.
Or call. Yeah.
They've been very nice. Very, very nice.
Yeah, I have to be cautious how I answer your questions. So
I
it's not
understand.
considered as legal advice, okay?
I had a feeling I was going in an area that I would be putting you on the spot, and I'm sorry for that.
Okay.
I'm so eager to have this done with, and at the same time, I want to do the best I can to represent myself, and I also want to stop this from happening. I know it's happening to other people too, so he needs to be stopped.
All right, so let me tell you my next available dates for
Okay.
small claims non-jury trials. The next one I have available is February 17th, but it sounds like that might be too soon if you need to look into subpoenaing a witness.
Oh,
The date I have after that is March 24th.
you know, let's go ahead and do February. I'll do my best. I'd like to have this resolved.
All right, let me count the days there.
I hope this is more general advice than legal advice that I'm about to ask. The man that hired me, is it any more relevant to have him appear via Zoom and say, yes, I did do that, when I already have documentation printed, and in the file that you'll be seeing, it's printed emails and printed texts from him stating, yes, you're approved to do the work. So does it even do any good to have him appear in person and say, yes, I did that?
So I can't answer that question for you.
Okay.
However, you might look at the Florida statutes under section 90, that's 90, which is the Florida Evidence Code.
Okay. Okay. I didn't realize how easy it was to not pay someone.
I'm not going to make any. All right, so you want February 17th. Do you prefer morning or afternoon?
I believe afternoon.
Okay, let me just check my docket for that date to see how many cases we have set.
I only see one.
I only see one also. Okay, let's set it for February 17th. At 1:30, that'll be via Zoom. So right now, I'm going to deny your motion for default and stipulation. Order that we have non-jury trial on February 17th at 1:30 via Zoom. I will issue a written order. That way you have a copy of it, and it'll include the Zoom codes for that hearing. And then we'll also send that to the defendant.
And may I receive a copy of his correspondence with you?
You can get that off the clerk's. Do you know how to access the clerk's showcase record system?
I tried and I wasn't successful.
Okay.
Do I understand correctly, though, that he should have submitted that to me as well?
That is correct. Okay. I can see if Julianne can email you a copy of that.
Thank you.
Your Honor, are you going to notice the next hearing?
Yes, I will issue an order and notice.
Thank you.
All right. Anything else, Ms. Colvin?
I don't believe so. I'll probably think of things after we disconnect.
Probably. That's what happens.
I know. Okay, well, thank you.
Anything else, Jane? Do we need anything else then on this case?
No, Your Honor, not on this case.
Okay. All right. Thank you, Ms. Colvin. We'll see you back February 17th at 1:30.
Thank you, Your Honor, and thank you, Clerk Jane. I appreciate your help, and I appreciate you advising me as you can.
All right. Thank you, Ms. Colvin. Have a nice afternoon. Stay safe.
You too. Thank you. Bye-bye.
Bye-bye. All right. Jane, are you showing one other case on the docket?
Yes. I'm showing Bright Smile Collections.
Huh.
Versus Robert Arencibio.
Do you see a notice in the file?
No. Well, no.
I don't either. That's odd.
It is.
All right, well, let's cancel the hearing and I'll have Julianne reach out to the plaintiff's attorney to see what happened.
Okay.
And then they can reset it.
All right. Thank you, Your Honor.
Okay, thank you, Jane. Have a good afternoon.
Thank you.
Take care.